The judge says to me, Mr. Oginski, call your next witness. I say, Judge, I have a surprise witness I'm calling to the witness stand now. The defense attorney jumps up and yells out, Objection, Judge! This is trial by ambush! You want to know what this means? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney practicing law in the state of New York. What does it mean when somebody says trial by ambush? It means that one side has not given the other side sufficient notice about something they want to do. And here's a perfect example. When an attorney gets up and says, Judge, I have a surprise witness I'm bringing in to testify, if I haven't notified my adversary that I'm bringing in this witness, he has every right to jump up, make a big stink, yell objection, say that I haven't given him sufficient notice. He doesn't know who it is that I'm bringing in. He hasn't had time to prepare a cross-examination for some witness that I didn't tell him about. And you know what? In many instances, he's going to be correct. And in many instances, the judge will be correct to turn around and say, Mr. Oginski, because you didn't notify the defense that you were going to be bringing in this witness, I'm not permitting you to put this witness on the stand and testify. And that means my surprise is gone. So what can I do in that instance in order to prevent this from happening? Well, one of the things that I have to do, especially if this person is an expert, whether it's a medical expert or an economic expert, I am required to go ahead and notify my adversary that I've retained this expert. And now I have to provide my adversary with this expert's credentials. Where did they go to school? Where did they do their training? And you know what else I have to tell them? I have to tell them what this expert is going to be talking about. I have to tell them what conclusions this expert is going to reach, and I have to tell them what's the basis for my expert's conclusions, so that now they can go ahead and try and identify who this person is, assuming it's a medical expert. You should know that in New York, we do not disclose the name of our medical experts, but we have to disclose the credentials. And with computer programs, it can easily be identified. But the defense wants an opportunity to go ahead and know this information beforehand, to do their research before the witness comes in, so they'll be ready to go for cross-examination. So why do I share this quick information with you? I share it with you because this happens often in these civil lawsuits involving accident cases and medical malpractice cases and even wrongful death cases. You know, I realize that you've got questions or concerns about your own particular matter. Well, if your matter did happen here in the state of New York and you're thinking about bringing a lawsuit, but you have questions that need to be answered first, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.